Well, many business relationships in agriculture are done on an informal basis, which can create legal issues when unexpected events occur. One of those being the matter of partnership creation. Roger McEowen with the Washburn School of Law joins us now with the very latest. Roger, good to have you with us. What are some of the main questions that might arise if there's no written partnership agreement?
Well, I think one of the big ones, Tammy, is if we have a tenant involved and we don't have a formalized agreement with that tenant, at what point in time might the tenant-landlord relationship rise to the level of a partnership? And that's a big issue and a big concern for a lot of landlords because they don't want to be in a partnership relationship just based on an informal agreement because of potential liability concerns. Partners are jointly and severally liable, and landlords don't want that. So you have to be careful not to shade across what the legal system might deem to be the line.
So at what point does a business arrangement constitute a partnership?
Yeah, well, there's no bright line for that one. The answer is that it depends, and it depends on a whole host of factors. And the tax court has its own list of 8 factors for determining whether one is in a partnership for tax purposes. And there are a whole host of those. And a lot of it comes down to how do you hold yourself out to the public? Are you driving around in a pickup truck that says ABC Farm Partnership? Or are you referring to your colleague down at the coffee shop or the co-op as your partner? Is there a separate bank account for the partnership? All those types of things, separate books and records. Are you filing a Form 1065, a partnership return? It just depends on how are you treating this and how would the public view the business relationship that you have. Those are the real big points.
Any examples you can share with us?
Well, we constantly have cases at the state level on the partnership issue, and I would just say ones that come to mind are recent ones out of Montana, some out of Iowa, some out of Kansas, just basically all over the country. In fact, there was a Tennessee case recently, and they arise in different scenarios. So you may have a partner that dies or a so-called partner that dies, and if they are a partner, then the surviving partner or partners will succeed to that interest rather than the deceased partner's spouse or vice versa. So that's an issue that comes up in addition to the liability issue that is potentially out there that seems to come up all the time. So you can get a whole bunch of different legal issues that come up based out of informal arrangements.
Definitely. That's Roger McEowen with the Washburn School of Law. Appreciate your time and input today.